Our next question is, how do the parties in law firm sales typically deal with ongoing ethical obligations, such as client retention, original records, and roles like trustee appointments? And this question is asked by Elizabeth Zelinka of Encoraco. So, Elizabeth, thank you for that question. When it comes to those different points that Elizabeth brings up, all of these points are negotiated when firms start their due diligence process. When a law firm is considering to purchase another firm, they're doing all types of due diligence in terms of finding out, all right, what is that final retention policy of the selling attorney? How do they handle original records? So just to get a little bit into the weeds, when we're negotiating law firm sales, we're typically identifying, when it comes to files, we're identifying the open matters. That's a no-brainer, right? The open matters come over to the buying firm. We're typically also saying, well, the recently closed matters, right? These are matters, let's say within a 7-year period, can be less, depending on the practice type. Perhaps those files are coming over to a buying firm as well. When it comes to closed files over a certain number of years, what we find often is that buyers really don't want to take on, particularly the paper files of senior attorneys that go back, let's say, more than 7 years, except for, as Elizabeth points out, original records, right? I mean, if you're an estate planning firm and you've got original wills and original other types of documents that are valuable to the future of the firm, then for sure those types of original documents can stay. But if, let's say, a real estate firm, and that firm that is the selling firm, happens to has the records from the sales that they were the lawyers on from 10 plus years ago, in our experience, often the buyers will say, please, you, Mr. or Ms. Seller, you need to either return those files to clients, destroy the files, or proverbially speaking, they wind up in the seller's basement. And by the way, that's not necessarily proverbially. Sometimes that actually does happen. Now, Elizabeth also asked about trustee appointments. So we talked to that specifically, and then more generally. What we find during the negotiations is that there can be what we call carve-outs. Okay, that is, on trustee appointments is a good example, because for estate planners, sometimes the clients will ask that a particular attorney, let's say as the senior attorney, would serve as the trustee or as personal representative, executor of a will. And that is something where the senior attorney may say, well, I'd like to continue in that role and be paid in a certain way because I'm really providing that service myself, and maybe that's not part of how we are otherwise categorizing the revenues that are going to come into the firm that a senior attorney can be paid upon. There also can be in certain transactions where there's certain cases where a senior attorney may say, well, we want special treatment for this type of case because I've been working on it for so many years, and I want, let's say, special treatment, carve-out type treatment. So I'll just point out again here that during the negotiations, the parties learn about all types of matters that a selling firm has, and that trustee type of matter and other types of matters could be subject to particular special terms, what we often call carve-outs.